The third most important writ as falling under Article 32 and Article 226 is the writ of certiorari. The writ of certiorari is the writ which is issued by the Superior Court, either the High Court or the Supreme Court, to the inferior court or tribunal or body exercising judicial or quasi-judicial functions to remove the proceedings from such court, tribunal or body for examining the legality of the proceedings if the order passed by the inferior court or tribunal or body exercising judicial or quasi-judicial functions is found to be illegal, the superior court may demolish it whenever any body of persons having legal authority to determine questions affecting rights of subjects having the duty to act judicially and acts in excess of their legal authority, certiorari may lie to quash a decision that goes beyond jurisdiction. The object of the writ of certiorari is to keep the inferior courts or tribunals or bodies exercising judicial or quasi-judicial functions within the limits of the jurisdiction assigned to them by law and to prevent them from acting in excess their jurisdiction. The writ of certiorari issues out of a superior court and is directed to the judge or other officer of an inferior court of record. It requires that the record of the proceedings in some cause or matter pending before such inferior court shall be transferred to the superior court to be there dealt with in order to ensure that the applicant for the writ may have a more and speedy justice. By means of certiorari, the superior court can demolish the order of the inferior court or tribunal or body exercising judicial or quasi-judicial functions if it finds the order illegal, but it cannot substitute its own views for those of the said inferior court or tribunal or body. It cannot be issued to quash an act or ordinance on the ground that it is constitutionally invalid, as it was decided in the leading case Prabodh versus State of U.P. in 1985 by the Supreme Court. So generally, who may apply? Then the person whose legal rights has been invaded may apply for certiorari. Thus the person aggrieved by the order may apply for certiorari. However, if the matter to be reviewed is one which affects the people generally, an individual citizen may ordinarily invoke the remedy of certiorari, as may such private citizen who suffers peculiar injury by reason of a judgment eh, or order in excess of jurisdiction. So, now we'll discuss regarding whom or against whom the writ certiorari can be issued. So, the very certiorari lies against an inferior court or tribunal or other body exercising judicial or quasi judicial functions. But there is the need of certain conditions to be fulfilled for the issue of the writ of certiorari. So it can be issued in case of the violation of the principle of natural justice. Certiorari is not issued duly to quash an action or order, but it can be issued to reinstate. However, it has been held in Prabodh versus State of UP in 1985 that certiorari cannot be issued to call for the record or papers or proceedings of any act or ordinance. So, the writ of certiorari lies in cases where the inferior court or tribunal or the body exercising judicial or quasi judicial functions acts without jurisdiction or acts in excess of jurisdiction or has abused its jurisdiction or has failed to exercise its jurisdiction. So also where there is error of law apparent on the face of the record, the writ of certiorari may be issued. Thus, if the decision of the inferior court or tribunal or body exercising judicial or quasi judicial function is vitiated by an error apparent on the face of record, certiorari may be issued to squash it. In such condition, certiorari will lie even if the inferior court or tribunal or body exercising certiorari will even if the inferior court or tribunal or body exercising the judicial or quasi judicial functions has acted within its jurisdiction for the purpose, the error must be error of law and also the error must be apparent on the face of record. So, also, where a judicial or quasi judicial authority acts in violation of the principle of natural justice, certiorari will lie against it. The court, tribunal, or any other body exercising judicial or quasi judicial functions are required to observe the principle of natural justice in discharge of such functions. If it passes any order in discharge of judicial or quasi judicial functions without observing the principles of natural justice, the writ certiorari will lie against such decision, and the decision may be quashed by means of certiorari. A judicial or quasi judicial authority will be disqualified to be a judge on the ground of bias or interest in the case if he has a direct connection with any party to the case or has pecuniary interest therein or has personal bias towards a party owing to relationship or is personally hostile to a party to the case. The second principle of natural justice is that no one should be condemned unheard. The person affected must be given reasonable opportunity of being heard before the decision is given. The person affected by the decision must be given reasonable notice of the case he has to meet and also reasonable opportunity to meet the case against him. So, also, now we'll discuss exactly how and under what judicial act certiorari is issued. So, it is issued against the judicial act which includes the quasi-judicial acts also. The writ of certiorari thus lies against the judicial or quasi-judicial acts of a authority. So it does not lie against the purely ministerial acts of such authority. As regards the issue of the writ of certiorari against the administrative bodies, the present position appears to be this that certiorari may be issued against such bodies if they affect rights of the individuals without complying with the principles of fair play. The principles of fair play require even an administrative authority to act in good faith and without bias and not to act arbitrarily or capriciously as it was decided in the leading case CIT versus Mahindra in 1984 by the Supreme Court, so also in the leading case Salini versus Union of India in 1981 by the Supreme Court. So, yeah, certiorari cannot be issued to squash an act or ordinance on the ground that it is unconstitutional or void. In such cases, certiorari could not lie, and also when there is adequate statutory remedies available, the court may refuse to issue the writ of certiorari in case the application for certiorari is presented before the Superior Court without first resorting to the remedy. However, this is not the rule of law, but only a rule of convenience, and the court may issue it even where the alternative remedy has been provided. If, in its opinion, the alternative remedy is not adequate and speedy, it has been made clear that the bar of alternative remedy would not apply where the fundamental rights are infringed or the defect of jurisdiction or the inferior court or tribunal has given jurisdiction by a law which is itself unconstitutional, as it was also held in the leading case Prabodh versus State of UP in 1985. So, In our upcoming video, we'll discuss the fourth important writ under Article 32 and 226 of the Constitution, and that is prohibition